I'm James Swartz with Swartz and Swartz. So a lot of our clients ask, what events happen during the course of the case that require their direct involvement? So there's at least a couple of them. One is the deposition, and another is potentially at least mediation. So depositions happen typically early on in a case, and they involve being in a room, or if it's being done remotely, by video conferencing. You as the plaintiff have your attorney next to you or with you, and the defense attorney is asking questions. There's a stenographer who's taking down everything that's said, so it's sworn testimony, it's a transcript that's formed that becomes evidence in the case. And the defense attorney has at least a couple of purposes in asking the questions. One is to unearth facts. They're trying to get information that maybe they don't have yet. And so they're trying to explore your knowledge about your claim, about your background, about the accident, things like that. Also, they're trying to establish a liability record. In other words, get admissions from you, maybe about how the accident occurred, that they feel will be helpful to their client. So those are some important purposes to keep in mind. We always advise our clients to make sure they listen carefully to the question that's being asked and answer only that question. So the defense attorney, if the defense attorney wants more information, the defense attorney will ask follow-up questions, and that's fine. But it's important to make sure that the defense attorney is doing his or her job, and that, again, you're answering only the questions that are asked of you. A mediation might occur further along in the litigation process after depositions have taken place, after there's been written discovery, after medical records have been produced and shared, and each side has all the information they need to really assess the claims, and the liability of the claims, and also the value of the claims. So the mediation process brings both sides together in one place. And the mediator is often either a retired judge, maybe an attorney, even a practicing attorney who's well known in mediation circles. It's important to note that mediations are not binding, so the parties voluntarily get together in a private mediation session typically to discuss resolving the lawsuit prior to trial. And if it doesn't get resolved, then the parties leave the mediation and simply continue on with the litigation toward trial, just as they had done before the mediation started. So again, there's no obligation to resolve the case, to settle the case, and the parties move on with the litigation process after that. So if you have questions about depositions, about mediation, should you bring a lawsuit, please contact Swartz and Swartz. We can answer those questions and we can help.